If your goal in 2026 is to build a consumer bankruptcy practice, the video today is for you. Make sure you have your pen and paper ready because you're going to want to take notes. I started practicing law back in 2009, right when the recession was hitting, and I built my bankruptcy practice from scratch, from the ground up, and I'm going to teach you how to do so today as well. I'm Darcel Lobo, a solo attorney who teaches you how to open and build a successful law firm. Today I'm walking you through the things that you need to get a bankruptcy practice with low overhead and high margins. Let's get into it. Now, the first thing we need to do is get clients in the door. Now, you don't need a big marketing budget to start a bankruptcy law firm, but you do need to make sure that you're showing up consistently where your clients are already looking. There's big firms out there that have the big marketing budgets. You're not competing with them as a solo, especially you want to keep your overhead low. So let's talk about things that you can do as a solo to keep the expenses low, but have a high return on the time that you're spending on your marketing effort. Now we're going to start with your Google profile. This is a non-negotiable. You must have a Google profile. You must have claimed your Google My Business profile as well and have filled that out entirely. If you have not done so, you need to do so right away. Make sure it's linked to the map where your office is located. Make sure there's a photo of you, of your firm, on your Google My Business profile. You're going to want to make sure you use the keywords that your clients are searching for in your Google My Business profile. So Chapter 7 bankruptcy attorney, Chapter 13 bankruptcy attorney, stop wage garnishment, stop foreclosure, terms like that, things that the clients are actually looking for when searching for a bankruptcy attorney. And with this profile, as you have clients, you're going to make sure you're getting them to leave you Google reviews. Don't worry about Avo, don't worry about FindLaw, don't worry about anywhere else. You need Google reviews for your law firm. Now, we talked about using keywords on your Google My Business profile. You're also going to be putting out content answering those questions that clients are searching. And so you're going to be posting these, whether it's social media, whether it's writing blogs, articles on your website, doing short form content for as far as videos or long form, whatever your preference is. We need to pick a plan, pick a frequency, which should be at least weekly, and start posting and putting out content about bankruptcy, answering the questions that your clients are looking for. And if you're not sure what they're looking for, go to answerthepublic.com and type in Chapter 7 bankruptcy, Chapter 13 bankruptcy, and it'll give you questions that potential clients are looking for when they're searching online for those kind of issues. If you're going to be utilizing short form video content, which I highly recommend that you do, make sure you are answering the simple questions your clients are asking. Can bankruptcy stop a lawsuit? Can bankruptcy stop a foreclosure? Can bankruptcy stop a garnishment? Will I lose my house in a Chapter 7 bankruptcy? Those are the kind of questions that your clients are searching up, so you want to make sure you're answering those questions directly. And when you're making this content for short form video, you're going to probably post it on YouTube Shorts, Facebook, probably not Instagram, because again, for bankruptcy, it is geographic as far as where you practice. And so you want to have people in your area who need a file. So probably Facebook is going to be a better fit for you than Instagram. Also, TikTok can be a good one, but again, TikTok is a national platform. It's not the same locality to it that Facebook does, but that can be a great one as well. Whatever platform you pick, just stick with it and post consistently. If I were to start over again, I would focus on my YouTube Shorts and on Facebook. And don't worry about overproducing your videos if you're going to do video content. Your phone and a ring light or in front of a window is all that you need. You don't need a bunch of bells and whistles to make this short form content answering these questions that your clients have. We also want to make sure that you are building referral relationships. So think about who is your client coming into contact with if they need a possible bankruptcy. This can be other attorneys, such as maybe family law attorneys if clients are going through a divorce and they may need a bankruptcy with the divorce. It could be criminal defense. There could be a number of other areas. Real estate as well could be a good one. So make sure you're looking at these potential options for cross referrals among other lawyers. But aside from just lawyers, think about who is your client talking to when they're having a financial hardship. Probably bankers, right? So your local banks, mortgage lenders, if they're having a hardship on their mortgage, real estate agents. A lot of clients will go to the real estate agent if they're having a hard time paying the mortgage because they don't know who else to go to, and that's who sold them the home. accountants. So think about who your client is talking to when they're realizing that they're having financial hardships, and then you want to create relationships with those people. Okay, so let's get to your internal processes, because we want to build your law firm as a machine. We don't want it to be a hot mess. So now that we focus on getting clients in the door, let's talk about what you do once you brought them in. So let's focus on intake. There should be kind of a scripted version for that initial intake over the phone. There should be qualifiers that you or your paralegal or your receptionist are asking of these bankruptcy leads. It could be things such as income, if they've had a prior bankruptcy, and if so, how long ago, if there's pending deadlines like a lawsuit or foreclosure. There are certain questions you want to ask so you can qualify people preliminarily kind of right away. Now, when it comes time for the actual consultation, you're going to want to see things like pay stubs you can calculate from the means test, right? You're going to want copies of any lawsuits or garnishments or foreclosure notices, right? So you're going to want to make sure you collect those things and have a secure way for clients to submit those to you. It should not just be through email, right? So a secure client portal or other way to securely get that to you. If you're doing a consultation in person, they can just bring it with them to the consultation with you. Now, once they've actually hired you and you have qualified them for a bankruptcy, whether it's Chapter 7 or Chapter 13, you should have kind of a standard bankruptcy packet that has a checklist of what documents you need, such as copy of their ID, Social Security cards, tax returns, proof of income, bank statements, creditor notices. Any documents that you need for the bankruptcy, you should have a standard checklist that you're giving to all clients for them to gather and provide to you, along with any kind of intake forms that you may have where you're getting more detailed information about like the year, make, model of their car and where they have bank accounts, where they have investments. This can be a paper packet. I have for years used a paper packet that I give people. There also are online options for them to fill this out online, but you want a way to gather that information as far as what their assets are and what their debts are. You're also going to be ordering their credit report from the Credit Report Bureau. But whatever bankruptcy software that you use, it should be able to automatically integrate that into the debt list in your bankruptcy petition. But besides just a credit report, you don't want to rely on only that. You want to actually get the statements from the client. So you have the additional address information for creditors, that you know the law firms handling those lawsuits, if there are any lawsuits. So you don't want to rely on just a credit report. You also want the client to give you the actual statements, letters, and collection notices that they've been receiving. Now, here's one point of caution for you as a bankruptcy attorney. Anyone could grab some forms for a bankruptcy petition and fill them out. Your job as the attorney is to know beyond just the forms, beyond just filling out the blanks, and that's the value that you provide. So we're talking about understanding transfer rules. If your client has transferred real estate, if they transferred money, if they paid any family or friends, if they paid certain creditors, or on a house that they did a refinance and got cash out on the refinance. So you need to make sure you understand things such as transfer rules, also your exemptions. You want to make sure that you understand if your state offers the option of using either state exemptions or federal, or if it's just one or the other, how they apply, what the limitations are, especially when it comes to real estate. And when it also comes to like personal injury claims or any future claims that your client hasn't thought of, you want to make sure your questionnaire is asking about those. If they're owed any past due wages, if they have any kind of L&I claims for injury on the job, if they had any car accidents, you want to make sure you're asking about those assets that may not readily come to mind for clients. Also, crypto can be a big one. So ensuring that you're asking all these questions so you can go, again, beyond filling out the forms, but actually providing the service as a bankruptcy lawyer. Also, for taxes, if you have a client who owes past due taxes, you want to ensure you're very clear as to whether or not their taxes may be dischargeable. Now, there are kind of general rules around that, right? So the taxes being more than 3 years old, not reassessed in the past 240 days. So there's different limitations, and you want to know if the IRS has any kind of lien recorded as well. But for my clients who have serious tax questions and serious tax debt, I will have them consult with a tax attorney to kind of assess what tax debt is dischargeable and what tax debt is not dischargeable. So even though I've been doing bankruptcy for 17 years, I still refer that piece of it out because that's just so detailed and a thorough analysis that I want to make sure that we have someone who knows tax law inside and out. And I have a handful of tax attorneys that I refer that piece to. So I would still do the bankruptcy, but for assessing dischargeability of taxes, I will refer that piece out and the client comes back to me so that we know what tax debt is and is not dischargeable. So they know what debt they're going to have after the bankruptcy is complete. So we're talking about you building a bankruptcy practice. But if you are new to going solo and you want to make sure that you don't make these same mistakes that law firm owners make sure you grab my free guide. It's linked down below for you on the 7 mistakes that law firm owners make and how to avoid them. All right, let's continue on. Okay, let's get into software. We're going to keep it simple, but we want it to be powerful and to work for you and for your team and help you save time and be efficient because the right tools can save you hours on case preparation. There's a number of options available for bankruptcy. Whatever bankruptcy software you choose, I highly recommend that you stick with a cloud-based option for bankruptcy software. So you have options such as Best Case, Jubilee, Next Chapter. There's a number of options when it comes to bankruptcy preparation. I use Best Case Cloud version. That costs $99 per month per user. So whoever else is on your team working on your bankruptcy preparation, it's going to be that fee per person per month. Jubilee has options that you can pay by the case. I think it's about $100 per filing. So if you're only doing 3, 4, 5 cases a year, that makes more sense. If you're doing more than that, I know Jubilee has other options as well beyond just pay by the case. So you'll want to assess what makes sense. I will tell you that switching from one bankruptcy software to another can be quite burdensome. So you want to do your due diligence before you pick one because having to switch to another is it can be done and I've had to do it, but it's not ideal. So whatever option you go with, just stick with cloud-based. Best Case has a cloud-based version, but also a desktop version. I would just avoid any kind of desktop version and stick with cloud. Now let's talk about document collection and e-signing because we talked about what documents you need to collect, but how are you going to store them? In my office, we use Dropbox. I love Dropbox, and for my risk tolerance, I think that Dropbox is a good option along with the other safety measures or security measures that I have in place with my office and with my firm and with my laptop and things like that. So that's what I use, and it's great for sharing with clients as well. A lot of your case management software systems also have secure portals to use, and so I've shared that I use my case so clients can upload documents there as well. Best Case also has an option for the clients to upload documents there. And what Best Case has recently added is this AI integration. So you can upload the proof of income and bank statements and it'll auto-fill petitions for you. I have not demoed it. Right now, I got an offer from Best Case to try it out on 10 cases for free. I haven't demoed it yet, but that is an option to look into as well, to use the Best Case AI option to help you in preparing cases. Whatever software you use, it should integrate with credit report, so it'll import all the debts for Schedules D, E, and F in your bankruptcy petition. Now, when it comes to signing the bankruptcy petitions, if you do it in person, then you'll have a wet signature. The other option for e-signing would be like a DocuSign or Adobe Sign. I use Adobe Sign because I have the Adobe Pro program, and so that comes with e-signing. So that's what I use with clients if we sign remotely through phone or through Zoom. When it comes to signing, those appointments take about an hour. I go over every page with my client. So from page 1 of the petition, through all the schedules, through your statement of financial affairs, the means test, everything. We go over everything page by page and I explain that to them. You want to make sure you are doing the same when you are reviewing and signing with the client. There's a number of times where you catch updates or edits that you need to make to the schedules where the clients may have forgot something just by mistake. And so when you're going through Schedule A and B and over all their assets, you're doing a double, triple check that you've covered everything and have listed all their assets and have listed all of their debts. Okay, let's get to pricing because we want to have a bankruptcy practice that has low overhead and high profit, right? And so how can we ensure your profit margins in a bankruptcy practice? So let's talk about Chapter 7 bankruptcy first. Those are flat fee. I have heard rumblings of attorneys taking a payment plan during the course of a Chapter 7 bankruptcy. I don't know how they do it. I would not encourage you to do that. I would not do that at all. My practice is that it's a flat fee, earned when received, and paid in full before I file their case. Now, for some clients, paying that flat fee up front can be a bit of a hardship, so I will offer a payment plan, but we will not file their case until they've paid in full. When it comes to offering a payment plan, I will not go longer than 3 months. So if they are not prepared to file their case and pay for it in full within 3 months, then they'll have to come back to us when they are ready to do so. Otherwise, we can break it into thirds over 3 months, or in half for, month 1 and month 2, or some clients are able to pay in full up front. For some clients, they may have family or friend who's willing to gift them those funds and to pay for it. So depending on what the options are, it's always going to be a flat fee. There's never a payment plan during the bankruptcy for a Chapter 7. As far as fees, I've seen attorneys be as low as $1,000. I've seen complex Chapter 7s and for businesses go upwards of $5,000. In my practice, I do not strive to be the cheapest attorney in town. If a client is looking for the cheapest attorney, I'm not the right fit for them. I usually charge about $2,500 flat fee for a Chapter 7 bankruptcy for one that's relatively simple. If it's time sensitive, if we have a pending lawsuit or garnishment that we need to stop, or a lot of creditors, it can go up from there. Now, I know that each market's going to be different. So what you can charge here in Seattle is going to be different than what you can charge maybe in a smaller town in the Midwest somewhere, or what's charged on the East Coast or down south. So I understand that. But I wanted to kind of give you an idea of what I see and what I charge for Chapter 7 bankruptcies for a simple one. Again, they can go up if they're more complex. Now, let's compare that with a Chapter 13 bankruptcy. Now, a Chapter 13 is a payment plan. So as compared to a Chapter 7, you can do a payment plan in the bankruptcy on a Chapter 13. However, you want to ensure you're getting at least a decent amount up front for your time in preparing the bankruptcy. For a Chapter 13, I would not accept less than $2,500 down for the Chapter 13 filing. It can go up from there. Again, if there's a foreclosure, time sensitive, a lot of creditors, a messy case, it will go up from there. But that is the starting upfront out-of-pocket cost, with the rest being paid through the plan. Now, in a Chapter 13 bankruptcy here in our district, we have what's called a no-look fee of $5,000. Each bankruptcy district has their own no-look fee. That means that you can get paid that amount without having to submit a billing to the court for your fees. Now, you should be still keeping track of your time so you kind of know how the time was spent and can back up the fees charged if you ever needed to do so, but you don't have to request approval for billing from the court for your no-look fee. If your case goes beyond the no-look fee, let's say there was a number of things that came up that your time went over that no-look fee, you can request a billing from the court to be approved for your fees that go beyond that no-look fee. So for here in Seattle, the no-look fee is $5,000. If that case charged, if I end up charging $8,000, I would have to do a billing to the court because I am over the no-look fee of $5,000. So that's fine, you can do so, but you have to submit a billing. And your district should have rules around billing as far as what's required for the billing. So you have to do the itemization in every 10th of an hour, and also need to identify who did the work on the case in your billing invoice, and make sure you check your local rules for any kind of billing requirements for your district. And remember, in your bankruptcy practice as the attorney, your value is not tied to filling out forms. Your value is for the client, for the peace of mind that you're providing them, the protection from creditors, the financial reset. That's what you are giving them and providing to them as the attorney and helping them navigate the bankruptcy process. And the last tip here we're going to cover is managing the cases once they've been filed. Because once they've been filed, you're just getting the case started. There's still quite a bit to go. So after you file the case, the automatic stay goes into effect as long as there hasn't been a recent prior filing. Assuming that there's not, the automatic stay goes into effect, stopping all foreclosures, lawsuits, collections, things like that. But then you're preparing for your 341 meeting of creditors. That's usually going to be about 30 days after you filed the case. Your date and time will be assigned to you about a day or two after you filed the case. That's going to be about 30 days out. Now, 7 days before that hearing date, your 4002 documents are due. What are 4002 documents? Those are documents you have to provide to the bankruptcy trustee at least 7 days before the hearing. This is 60 days proof of income, recent bank statement for all bank accounts. So if they have 5 checking accounts, you have to provide the recent statement for all 5 accounts. This also includes any kind of online payment accounts, your Venmo, your PayPals, any kind of financial accounts you need to give a recent statement for to the trustee as a part of these 4002 documents. Practice tip here. If a client comes to you and they have 10 bank accounts, which has happened, if not more for some clients, you're going to have them close the accounts that they're not using. There's no good reason to have so many bank accounts. That just creates more paperwork, a messier bankruptcy, more 4002 documents. There's no need for it. Have them close most of those accounts and they can keep 2, maybe 3 open. But you don't want to deal with 4002 documents for 10 plus bank accounts. It's just more work for you. Also, you have to provide a recent tax return. That is required. So if a client comes to you in a consultation and they have not filed taxes in a number of years, they need to get that done because you have to provide the recent filed tax return to the trustee as a part of these 4002 documents. And there's also going to be a declaration that the client signs saying that those documents are truthful and accurate and being submitted to the trustee. After you've had your 341 hearing, the only last thing to do is for your client to do their second credit counseling course. It's called the Personal Financial Management course. They had done one before they filed the case, and after the case is filed, they have a second one to do. It usually costs around $25 to $40-ish for that course. They can do it online or over the phone. Usually it takes about an hour for them to complete. So you have to file that with the court as well. And then you're waiting for your discharge to come in a Chapter 7 case. That comes about 60 days after that 341 hearing. So in total, it's about 90 days. I usually see about 94 to 95 days for a Chapter 7 from start to finish with the court. For a Chapter 13, once your case has been confirmed, then your client is off making their payments on their 3 or 5 year payment plan. So this is kind of a short overview as to a bankruptcy practice, how to build it, and how those cases will flow, and how you're going to get bankruptcy clients in the door. If you want to open your own law firm and you're thinking about doing bankruptcy, make sure you watch this next video. I'll have it linked up here for you on how to start a law firm from scratch in 2026. And I'll see you in the next video.